Acting President, in my capacity as Chairman of the Subcommittee on Proposed Senior Judicial Appointments, I wish to report briefly on the deliberations of the Subcommittee. The Subcommittee notes that the Judicial Officers Recommendation Commission, JORC, made recommendations on judicial appointments in accordance with Article 92 of the Basic Law, which provides that judges of the Hong Kong Special Administrative Region shall be chosen on the basis of their judicial and professional qualities alone. However, members have urged for greater transparency and accountability in the senior judicial appointment process, such as making the criteria for appointment clearer for better public scrutiny in the future. Members have also raised concern about the independence of the senior judicial appointment process because the Secretary for Justice, being one of the principal officials under the political appointment system, is a member ex officio of the JORC. The administration has explained that the membership of SJ in the JORC would not undermine the independence of the senior judicial appointment process, being the principal advisor on legal matters to the Chief Executive and the head of the Department of Justice. SJ is in a unique position and has a considerable knowledge to contribute to the JORC's deliberations in respect of judicial appointments. According to the administration, such views are also shared by the Judiciary. The subcommittee has considered the supplementary information provided by the administration on the proposed senior judicial appointments. The subcommittee supports the appointments of the Honourable Mr. Justice Joseph Fok, SC, JP, as the permanent judge of the Court of Final Appeal, the Honourable Mr. Justice Patrick Chan Siu Hoi as a non-permanent Hong Kong judge of the Court of Final Appeal, the Honourable James Spiegelman, ACQC, and the Honourable William Gamal, AC, as the non-permanent judges of the other common law jurisdictions of the Court of Final Appeal as recommended by the JORC. President, I shall now state my personal views on the matter. William Blackstone, an English common law jurist in the 18th century, once said that in this distinct and separate existence of the judicial power in a peculiar body of men, nominated indeed by but not removable at the pleasure of the Crown, consists one main preservative of the public liberty, which cannot subsist long in any state, or in our case, a special administrative region, unless the administration of common justice may in some degree separate it both from the legislative and also from the executive power. Were it joined with the legislative, the life, liberty, and property of the subject would be in the hands of arbitrary judges, whose decisions would be then regulated not only by their own opinions, and not by any fundamental principles of law, which though legislators may depart from, yet judges are bound to observe. Were it joined with the executive, this union might soon be overbalanced for the legislative branch. It is therefore of utmost importance that we do not interfere with the work of the judiciary in both the judicial appointment process and the work of judges in the courtrooms. Members of the executive branch, the legislature, and the judiciary should all act in accordance with our constitutional duty to uphold judicial independence. I hope we'll all dedicate our efforts in protecting the independence of the judiciary, in safeguarding the independence of the judiciary, which is the bedrock of our rule of law. President, the JORC bears the responsibility of appointing judicial members based on their merits and professional judicial qualities. Judges appointed must be independent in their judgment, free from any interference, no matter whether they are from the public, from the rich and the powerful, or from government. The appropriateness of the membership of the Secretary for Justice has been frequently questioned by the Bar Association, the legal profession, and some members of this council. The Secretary for Justice is a political appointee from the administration and is held responsible for all prosecutions and in any judicial reviews concerning the government. This poses the question of whether the presence of the Secretary for Justice in JORC is appropriate, indeed whether he should be an ex officio member of JORC. This opens a gap for the potential interference with any decision of appointment of judges. More importantly, President, this gives the public a perception of interference. This arrangement may weaken the confidence of the public on judicial independence. And I must emphasize that the judicial appointment process must guarantee the quality and independence of those appointed, and the current institutional framework could be better reformed to serve this ultimate aim and purpose. Let me make one thing clear. We do not want, nor do we need, a politicized judicial appointment process in Hong Kong. In fact, I'm well aware that personal remarks against any judges cannot be made in this Council except in accordance with specific rules of procedure. We must not use our parliamentary privilege to interfere with the independence of the judiciary. We, as members of the Legislature, should honor our constitutional duty to uphold judicial independence. Yet our duty to ensure judges are free from interference includes also our duty to ensure the integrity of the judicial appointment process. We shall relentlessly seek the improvement of the system and framework in the JORC. The aim must be ever more fairness, transparency, and accountability throughout the entire process. Like the rule of law, the process of judicial appointments should be brought under the sunlight to be seen by all. Thank you, President.